The plain reading of the above provision shows that sub-rule contemplates withdrawal of suit, which is optional to the plaintiff and can tender request to that effect at any stage of the proceedings, however, per sub-rule, the plaintiff, while showing formal defect in the plaint or asserting some other sufficient reasons, may withdraw his suit with liberty to institute fresh one. Full stop. Where he does not intend to institute a fresh suit, or he simply withdraws a suit without seeking permission to file new one, then according to sub rule, the plaintiff is precluded to institute second suit qua subject matter of the earlier list. Full stop. The object of last principle is to prevent a plaintiff from reopening of another round of litigation, which he already has dropped, otherwise, there would be no end to the litigation. Full stop. Thus, clear that though plaintiff has a right to withdraw his suit wherever he desires, but he cannot bring fresh one qua same subject matter, unless permission is sought in this behalf. Full stop. Moreover, section 12 of the said code provides that where a plaintiff is precluded by rules from instituting a further suit in respect of any particular cause of action, he shall not be entitled to bring a suit in respect thereof in any court to which this enactment applies. Full stop. The main object of these provisions is to prevent endless litigations and to save the precious time of the courts. Full stop. Although, no cross objections in written form were filed, but learned counsel for respondent orally challenged findings on issue number 5, which he could do while supporting the impugned judgment on other issues, even if formal objections were not moved. Full stop.